Hello there, I'm Blackbright, and I haven't done a immigration video for quite a while. So I was looking through the Richmond Chambers website, and I found something quite interesting that might be of use to some people who are victims of domestic abuse and they still want their indefinite leave to remain. Some people might say, well, if you're a victim of domestic abuse, why don't you just try to get as far away from this man as possible or this woman? Go back to the country that you originate from, which should be safer, rather than subject yourself in this country in a situation where you're compromised, because a lot of victims of domestic abuse tend to be stalked. They tend to be intimidated. They have financial abuse and all kinds of things going on. So some people might have their little thoughts about it. But anyway, the law is the law, and it's not very easy to get through the red tape of the law, even if you are a victim of domestic abuse. But it is one of the avenues to get indefinite leave to remain if you are a victim of domestic abuse and you can prove it. How you prove it, you might just think, well, I'll show them a couple of photographs of my face smashed in. No, that's not going to cut it. I'm going to show that he's broken my arm, that he's, that I've been stabbed. That's not going to cut it unless you've reported it, unless it's documented, unless you've had a social worker, unless you've gone to a refuge. It's not going to cut it. You can't just go to the police and say, I'm a victim of domestic abuse, and that's it. It needs to have been reported as a crime. It needs to have, you need to have hospital records, GP records, and all sorts. Anyway, the source is Richmond Chambers, and I'll just read through it as I usually do, so I don't miss out anything. And it's not my area of expertise. So like I always tell you, please contact a reputable immigration lawyer. And I'll give you the number of Richmond Chambers at the end of this video. So the Home Office guidance. What is domestic abuse anyway? People kind of think that domestic abuse is just slapping someone around. But it's not. It covers a gamut of things. And you might not even know that what you have been doing to your partner constitutes domestic abuse. And victims of domestic abuse might not realise that the behaviour of their partner is reportable. So the Home Office guidance reflects the fact that domestic abuse takes many forms, including psychological. That's when a man tries to make you feel as though you're going crazy. I don't know how you prove that, but it could be you're in a relationship with a narcissist. But like I said, how you prove that, I don't know. Physical, well, of course, you can prove physical because you should have the evidence of bruises and broken bones and goodness knows what. Sexual, that's rape. And I guess you would have had to report that to a hospital or a GP. Financial, that's where he's taking all your money, your salary. You might have a joint account and he's dipping into that. He's not allowing you to access your money, maybe because you're in a vulnerable position. You're not here in the country without his say-so, without his authorization. So he can abuse you financially. And emotional abuse. That is a bit like narcissistic abuse, but it's also to do with the mind, the fact that they can ignore you, stonewall you, and that kind of thing. It is defined in the guidance as an incident or pattern of incidences of controlling, coercive, or threatening behaviour, violence or abuse between those aged 16 or over, who are or have been intimate partners of family members, regardless of gender or sexuality. So domestic abuse has to be within an intimate relationship. Controlling behavior is defined as a range of acts designed to make a person subordinate or dependent by isolating them from sources of support. You find a lot of people, they try to stop you from accessing your friends. You might say, how can they do that? But they do. They do it from the beginning. They make it look like your friends are a bad influence, or your friends are not going to help you, or your friends are not really friends, and they tend to isolate you from your friends and your family. You make one little complaint about your family and say, oh, my mum did this, or my dad did this, or my brother did this. The next thing you know, oh, they're not good for you. They don't have your best interests at heart. I don't think you should speak to them anymore. Now you have me. You just need to concentrate on me. They kind of switch it. So anything you tell them about your friend or your family goes against you, and they end up forcing you to turn your back on your family. They exploit their resources and capacities for personal gain. Well, I can't think of an example of that. But I would think that it would mean, like, if you had some money, or if you had a home, or if you had something, they would exploit it so that they can benefit from it. Depriving them of the means needed for independence, resistance, and escape. That is like those partners who prevent, like I said, their spouses from access to money. They keep them in the house. They don't give them a key. They're like prisoners, really. So, and they can't escape either. Some of them have them as sex slaves. Some of them have use them for trafficking and make money from them. And then they regulate their everyday behaviour. So everything that they do is under scrutiny. Can you imagine? Can you imagine living like that? Like, from the moment you wake up, you're being watched, you're being monitored. You can't go to the toilet without them, say, keeping the door open. You have no dignity. That's what it's like. Coercive behavior is defined as an act or a pattern of acts of assault, threats, humiliation, and intimidation. Other abuse that is used to harm, punish, or frighten the victim. Well, that's self-explanatory. There are non-exhaustive definitions. So there are other definitions that are quite long that they're choosing not to put in this article. What are the requirements for indefinite leave to remain as a victim of domestic abuse? Well, to be granted ILR, which is indefinite leave to remain, as a victim of domestic abuse, you must fulfill 4 main requirements. You must be physically present in the UK when making the application. So you can't be in another country as a victim of domestic abuse and make this application. You need to be in the UK. And it cannot be made on your behalf by somebody else living in the UK. You must make a valid application for indefinite leave to remain as a victim of domestic abuse. That's the second one. And basically, you need to apply using the specified application form, complete all mandatory sections on the form, pay the specified application fee, I think it's over £2,000, provide proof of identity. If under 18, provide written parental consent, comply with the application process, including the requirement to enrol for biometrics. Now, the problem with this is that if you're with an abusive partner, he's likely to hide your passport, hide your ID, take away your money. If you're dependent on him for money, how are you going to pay the fee of over £2,000? But that's the criteria. And I'm sure if there are mitigating circumstances and you have a good lawyer, they might be able to help you if you don't have the documentation that you require. The validity requirements are contained in paragraph 34 of the immigration rules and helpfully explained in the Home Office guidance document. So if you go into the Home Office guidance and you put in ILR for domestic abuse, it will come up. The application fee is £2,389 per person. You also need to pay £19.20 per person to have your biometric information, which is your fingerprints and your photo, taken, which means those spouses and partners, like I said, who are victims of domestic abuse, financial abuse, and emotional abuse, and hold the purse string, these victims are totally screwed. Now, I don't know why it cost £19.20 to take a photo and put your finger on a machine, but that's how much it costs. Okay. You do not need to pay the fee if you can provide evidence that you do not have a place to live and cannot afford one. Now, will they look on that as an encumbrance? I don't know. You have a place, but you cannot afford essential living costs like food or heating, or have a very low income and paying the fee. Now, with their banner that they want the brightest and the best, how are they going to relate to that? How are they going to treat that? The fact that you want to stay in this country as a burden, you don't have a job, you don't have any ID, you don't have any money. And that's the way sometimes they see this. They have systems in place to protect you and to support you, but number one, there is something in it for them. And the main thing that's in it for them is that they need to have the perpetrator, i.e. the person who has committed domestic abuse, so they can throw his butt in jail and they can get some income. At least that way, they get some income from him being in prison. And if you decide to stay, I don't think it will half compensate for if you stay in the country. And you can't afford to live. But hey, I don't know how it works. You get indefinite leave to remain, I guess you can claim benefits. But yeah. You don't have to pay the immigration health surcharge. That's £624 if you enter the UK under this route, i.e. domestic abuse. And it can only be domestic abuse. You can't say my relationship broke down because my husband was unfaithful, for example. And then he started, I don't know if after he was unfaithful and then he started beating you up, whether that would constitute the only reason. But the thing is with this particular route is that it has to be based on domestic abuse, nothing else. Okay, so proof of identity. Oh, I think I've jumped a bit. However, you do not need to pay the fee if you can provide evidence that you do not have a place. Oh, I've said all of that, haven't I? You do not have a place to live and cannot afford one. Have a place to live but cannot afford essential costs like food and heating, or have a very low income and paying the fee would harm your child's well-being. So it looks like you need to have a child, or I don't know. So there is no immigration health surcharge, as this is an application for indefinite leave to remain. So I was right, proof of identity. What if my abuser has taken my passport? You'll find, like I said, a lot of abusers, they are going to make you as vulnerable as possible and hide your documents or take your documents out of the house and put them somewhere. So you're totally dependent on them. Paragraph 34 states B in open paragraphs, B closed paragraphs. Proof of identity for the purpose of this paragraph means a valid passport, or if the applicant, except a PBS applicant, does not have a valid passport, a valid nationality identity card, or if the applicant does not have a valid passport or national identity card, their most recent passport, or, in brackets, except a PBS applicant, their most recent national identity card, or if the applicant does not have any of the above, a valid travel document. How did they get here? But my view is that if they've taken away the passport, they've taken away the national identity card, wouldn't they also take away the travel document? If they wanted to kind of imprison that victim. So if you cannot provide any of these documents, paragraph 34 in brackets C close brackets, open brackets 7 close brackets, allows you to raise a good reason why not. And you must meet, this is the third one, you must meet the suitability requirements. The suitability requirements have two parts. The mandatory requirements, which, if not met, must result in refusal of your application, and the discretionary requirements, which, if not met, may result in refusal of your application. So one is must, the other one is may. You may fall foul of the mandatory requirements if, for example, you have previously been convicted of crimes or failed to comply with the previous immigration requirements. The discretionary requirements may apply to you if, for example, you have provided false information, failed to disclose material facts in relation to your application, or the Secretary of State believes your presence in the UK is not conducive to the public good. And there are some people, you wouldn't believe it, but they actually get their partner to beat them up so they can get an indefinite leave to remain. That won't work. There has to be a series of serious beating. So if you want to go through that and you still ain't going to get it because of whatever, that's up to you. Trying to get an indefinite leave to remain through domestic abuse is not fun. It's humiliating. It means that you have to put your partner in prison. So it's not something you want to make up to try and get your ILR. Don't think that you can get one little beating and that's going to do it. It's not. So you must meet the eligibility requirements. The three eligibility requirements are that 1, you have had leave to remain as the partner of a British citizen, person with settled status, person with leave to remain as a refugee, or person in the UK with leave to remain under Appendix EU. 2. Any subsequent grants of limited leave were granted, 1, as a partner, 2, to enable access to public funds pending an application under DVILR, which is the domestic abuse application for indefinite leave to remain, or 3, under D-BVILR.1.2, and 3, you have provided on the balance of probabilities that during the last period of limited leave as a partner, your relationship broke down as a result of domestic abuse. Now, I don't know why it's restricted to the last period of limited leave to remain of your partner. Not quite sure. I guess it's because prior to that, you should have reported it. And if you'd reported it, that leave to remain wouldn't have been extended. So that's just my thoughts. So the fact that you didn't report it, I would, the way I think they're thinking is that whatever happened, this breakdown of the relationship that resulted in domestic abuse had to have started in the last leg of the indefinite leave to remain. So you want to know if you're eligible if you were granted leave to remain as a fiancé or proposed civil partner. The answer is no, not unless you were subsequently granted leave to remain as a spouse, civil partner, or person who has been living together with the applicant in a relationship akin to a marriage or civil partnership for at least 2 years prior to the application. And like I've said in previous videos, this isn't something you can just make up. You can't just go to the Home Office or write on the form, we've been together for 2 years, because if you do and you haven't got the evidence to prove it, you're going to be done for fraud. And that means no entry into the country for 10 years. So don't lie about it unless, no, not don't lie about it unless, but don't lie about it because you will need evidence of the partnership for 2 years. Evidence of living together, joint tenancies, joint mortgages, joint bank accounts. That is what they call commitment. Things that are joint. If it's not joint, you don't count. The relationship doesn't count. Counts, your bills, are they joint? And the thing is that you're taking a big risk if you're trying to get your indefinite leave to remain based on the fact that you've been with your partner for 2 years when you haven't. Because if your partner isn't kosher, you don't know what he's going to do with your joint details and your joint assets. So what I'm saying is, it's best to be upfront. It's best to be honest. It's not worth trying to finagle your way into the country. It's just not worth it. Okay, if I'm an overstayer, but last had to leave to remain, but last had leave to remain as a qualifying partner, am I still eligible? If I am an overstayer but had leave to remain as a qualifying partner, am I still eligible? I mean, the solicitor is saying yes. I'd be very, very hesitant if I was an overstayer. And you had your leave to remain as a qualifying partner. But why didn't you regularise your stay if that's the case? Anyway, Richmond Chamber says yes, it is advisable to regularise your stay as soon as possible if you last had leave under Appendix FM. That's a family member. How will the Home Office assess whether my relationship broke down as a result of domestic abuse? The Home Office guidance states that all evidence submitted must be considered, and a conclusion drawn as to whether there is sufficient evidence to demonstrate that, on the balance of probabilities, the breakdown of the relationship was as a result of domestic abuse. And what they're also saying is that if you don't have the evidence, the clerk shouldn't automatically assume that it didn't happen. So I don't know quite how that works. So evidence might include photographs, crime photographs of the marks and the any stitches, any cuts, any bruises. Crime reports, police report with dates, hospital visits with dates, GP notes with dates, and of course you can't have any criminal convictions. So if you're a victim of domestic abuse and you've got criminal convictions, not good. Regardless of who you are, as long as you're a foreigner and you have criminal convictions, you're not allowed here. Regardless of how those criminal they make out like it has to be serious, but it doesn't have to be serious these days. It all depends on, how they can portray the crime. So, evidence of a criminal conviction, evidence of police cautions, a final order in a civil court for a non-molestation order or occupation order. All of this stuff you're going to need. A multi-agency risk assessment conference, MARAC referral, confirmed by any person who is the member of a MARAC. MARAC is something I actually work on in my workplace. I don't know how they would get a copy of the referral though. So they're not asking for simple stuff. Yeah. A charging decision. A domestic violence protective order. This is what you're going to need as evidence. A forced marriage protection order. Prohibited steps order or contact orders. A letter from social services or a welfare officer connected to the HM Armed Forces confirming that the author has assessed the applicant and considers them a victim of domestic violence. A letter from an organisation that supports victims of domestic violence, including a refuge, that's like Women's Aid, something like that, confirming that they have assessed the applicant as being a victim of domestic violence. Such letters should detail the support being provided. So they not only must you say you've been there, but they have to itemize the support they're providing for you. So you can't just have gone in there one day and as a victim of domestic abuse and then come out the next and think, okay, that's going to be sufficient. At least I'm documented as going in. No, they want written evidence of the services they provided to you. A letter or statement from an independent witness verifying that they witnessed the incident of domestic violence firsthand and they have no vested interest in the case, i.e. they're not related to you. Evidence of an arrest. So, that, like I said, if you're reporting an abuse and you're trying to do it to get ILR, you're gonna take that risk of putting your partner in prison. So it better be an authentic claim. Ex parte orders, a decision made by a judge without requiring all the parties to be present. So if you've got one of those, if you've got interim orders, if you've got an undertaking to the court, a police report or attendance at the domestic violence incident, a medical report from UK hospital confirming injuries or condition consistent with domestic abuse, and lastly, a medical report from GP or medical professional confirming injuries or conditions consistent with domestic abuse. So you can't just go there and say, oh, I've got a bruise and my mailman beat me up. You could have fallen down the stairs. You could have fallen off of a bike. You could have fallen off of a horse. So what they're saying is it has to be consistent with domestic abuse. So it's not even like you can make it up. You can take all these licks and everything. And if it's not consistent with domestic abuse, they're going to throw it out. So it should be noted that letters or statements, I've got to speed this up. It should be noted that letters or statements from official sources, such as advice agencies, repeating the applicant's account without confirming that the applicant has been assessed as or is being treated as the victim of domestic violence, will be regarded as weak evidence, though such evidence must be considered in light of the rest of the evidence. Similarly, statements from the applicant will be regarded as weak evidence unless it is corroborated by stronger proof such as police reports or medical evidence. So that's basically what I was telling you. It's not just hearsay. That's not going to cut it. You need to put some people in some serious trouble in order to get, if you want to get your ILR. Caseworkers cannot infer that an applicant's claim for domestic abuse is falsely simply because certain evidence has not been provided. So the caseworkers who work on domestic abuse, they can't just say, oh, because they haven't provided all this evidence, that means they're not a victim of domestic abuse. They have to squarely confront reasons given for why evidence has not been adduced. The judge said that, I'm not going to read all of that. Okay, I'm just going to read one of the reasons why. some applicants don't report. A sense of shame, cowardness. Some of them, they still have residual love for the person who's beating them, despite their behaviour, and fear of losing him or her or getting them into trouble. So that's sometimes the reason why people don't really want to betray the abuser. The judge said that these explanations all strike me as being inherently plausible and the fairly typical response of an abused partner in a relationship. They provided at least an equally convincing explanation for why the claimant said nothing at the time as the one reached by the Secretary of State, i.e., that he had not been assaulted by his wife. Fairness required the Secretary of State to address it. So sometimes you get them withdraw when they put in a claim for domestic abuse, when they realise everything that's involved and how they, I don't know whether the person beat them up or not, but the information required, some of them withdraw. They withdraw the application. So what does during the last period of limited leave as a partner, your relationship with your partner broke down mean? What does during the last period of limited leave as a partner, your relationship with that partner broke down mean? The Home Office guidance states that applicants must establish that the relationship was subsisting at the start of the last grant of leave as a partner. I think I mentioned that. Applicants should therefore show evidence of before and after the abuse in order to satisfy the Home Office that the abuse broke down within the specified period, i.e. broke down within the last period of leave. Now, are you going to be taking photographs all over the bloody place? So you can show photographs before and photographs after the incident. How do you do that? That means you're being premeditated, I would have thought, unless you're just taking random photographs. I don't know. The Home Office guidance states that applicants must establish that the relationship broke down because of domestic violence. This means there must be a causal link between domestic abuse and the relationship breaking down. How much influence the abuse needed to have on the relationship breakdown is not specified in the rules, guidance, or case law. So you don't know how much abuse you're supposed to take, before it qualifies. In practice, where it is established that domestic abuse occurred and the relationship is broken down, it is presumed that domestic abuse was the cause of the relationship breakdown. Only in exceptional circumstances is it likely the Home Office would accept that there was domestic abuse but refute that it was the cause of the relationship breaking down. So, another question, will I have to do a life in the UK or English language test as a part of domestic violence and indefinite leave to remain application? There is no requirement for applicants to do a life in the UK or English test. The Home Office guidance confirms this. The applicant does not need to demonstrate knowledge of language and life in the UK under the Victims of Domestic Violence rules. It seems like they're coming in almost like refugees. What is the average processing time for DVILR? You'll usually get a decision about your application within 6 months, according to the government website. If I'm refused DVILR, do I have a right to appeal? There is no automatic right of appeal, as confirmed in the Home Office guidance. An applicant who applied on or after the 6th of April 2015 will not have a right of appeal. Instead, they may be able to have their decision reviewed under the administrative review process. The relevant provision is contained in Appendix AR, Administrative Review of the Immigration Rules, AR 3.1, provides that the administrative review is only available where an eligible decision has been made. The application for administration review must be filled within 14 days of the decision from the UKVI and cost £80, which is refunded if the decision is reversed. You should receive a decision within 28 days. A right of appeal arises under Section 82 in brackets 1 in brackets B of the Nationality, Immigration and Asylum Act 2002, where the Secretary of State has decided to refuse a human rights claim under Section 113 in brackets 1. A human rights claim is a claim made by a person to the Secretary of State at a place designated by the Secretary of State that to remove the person from or require him to leave the United Kingdom or to refuse him entry into the United Kingdom would be unlawful under Section 6 of the Human Rights Act. Needless to say, many people making a DVILR application would also have a legitimate human rights claim, for example, if they fear they would be subject to violent treatment in their home country, Article 3, or they have substantial family ties in the UK, Article 8. However, raising these points on your DVILR application, for example, in your witness statement, or even using the words, I hereby make an Article 8 claim, is not enough to entitle you to a right of appeal. And it'll probably wind them up anyway. So try to avoid that. You can get around it by putting your point down, but not showing your savviness. If your first application, for example, your DVILR is refused, you will become an overstayer and therefore subject to Home Office hostile environment policy. No jobs, no home. No jobs, no home, no healthcare. Your leave to remain would not be extended by Section 3C when you made a second application, in this instance, the human rights application. So they get ticked off right there. In view of this unhappy situation, it is therefore vital to choose the application that suits you best or suits your situation best. If you're in this position, it is highly advisable to seek advice on the merits of the different types of application you could make. And you can contact the Richmond Chambers immigration barristers for expert advice and assistance on indefinite leave to remain as a victim of domestic abuse. Contact on 0203 617 9173. That's 0203 617 9173. And do let me know if you found this useful. Bye bye.